right to privacy started on the 11th of August of 2015. By that time, Aadhaar was being implemented by executive instructions. And the Supreme Court said that, look, you can't have Aadhaar for not more than 6 items. That is your ration card, gas connection, 3, 4, 5 items were there mentioned by the Supreme Court. As the hearing was to start, the Attorney General made a statement that there is no fundamental right to privacy in India. The moment he said it, the judges told him, on what basis are you saying it? And he referred to 2 judgments, one of 1954, which was rendered by 8 judges, and one in 1962 rendered by 6 judges. It's odd that they were of even numbers, but that's how the strength was. Now, so once this statement was made by the Attorney General, the senior most, the law officer of the country, the judges said, okay, we'll refer it now to the Chief Justice to constitute an appropriate bench and decide whether at all there is a fundamental right to privacy. Frankly, as a lawyer, I thought this was a clear delaying tactic, because by the time the Constitution bench decided whether we have a right to privacy, it was the 23rd of August 2017. So 2 years passed, and from some 10 or 20 crore Aadhaar card holders, we came to 100 crore Aadhaar card holders. It is also astonishing that he said that there is no right to privacy, because if you check SEC, you will find that before the Aadhaar judgment, there are 64 Supreme Court cases where they have used the word right to privacy. So there was really no debate. But why did it happen? I'll first deal with that, then I'll also discuss briefly the law of privacy, and then I'll go to the right to privacy in a digital age. You see, in 1954, just see how events turn and lead to momentous occasions. In 1954, the Dalmia company was raided. Those of you who are lawyers would have heard Aram Krishna Dalmia. Right? The industry went to the dogs, but at least they had some contribution to develop the law. So I keep telling my friends from Calcutta, I said, if you don't have industry, at least you have developed the company law. So anyway, so in 1954, the Dalmia company was raided, and the Department of Company Affairs seized some records. He said, you can't seize those records because they violate my right of Article 20, right of, it will be a question of self-incrimination. 23 is a bar against the search, a simple point. Supreme Court obviously said that there is no question of your fundamental right being violated, you have violated the Companies Act, they have seized some record, what is the big thing about it? But in that 8 judges judgment, Justice Das makes an observation, passing, saying that unlike the 4th Amendment in the US Constitution, we do not have a right to privacy. So he said India doesn't have a fundamental right to privacy. That statement was there. Now, ironically, if you see the 4th Amendment to the Constitution, there is the word right to privacy is not used anywhere in the US Constitution, nor in the Indian Constitution. What the 4th Amendment says is, you know that the US Constitution came in 1776 and all the rights subsequently came in 1789. And the 4th Amendment says, briefly speaking, that your house cannot be searched. There's a bar against unlawful searches of a person's home, his physical space. And that really is based on Lord Coke's dictum that every man's home is his castle. So this was an observation saying that unlike the 4th Amendment, we don't have a fundamental right to privacy. End of the story. 1962 came that historic case of Khadak Singh, where what happened in the UP, in the state of Uttar Pradesh, the police could do 4 things. They could have surveillance over you, they could maintain your records, they could ask for your, ask you to come for inspection, and the last and the most dangerous was, they could make domiciliary visits were permitted. Now these domiciliary visits were done at night, and Mr. Khadak Singh, who was admittedly a person with a criminal record, he complained to the Supreme Court that, look here, the daroga, the police officer comes to my house at odd hours of the night and asks me where did I go, what did I do, who came to my house, and so on and so forth. And he said, this violates my right to privacy. Now in this subsequent Khadak Singh case, it's a judgment of 6 judges. There they say the UP police can ask for records, they can maintain records, they can ask you details, but they struck down the provision regarding domiciliary visits. They said visiting a place person at odd hours is completely unconstitutional. So these are the two cases which then, and then after that there was nobody bothered about the right to privacy. Our Attorney General said that India doesn't have a fundamental right to privacy. Just a few historical background of the US Constitution which will tell you, the topic is right to privacy in a digital age. And you will find that this right to privacy is going to be from the, not only Stone Age, but the electric age, the information age, digital age, and I don't know what future age is going to be ahead of us, and how the right to privacy will be all pervasive. And look at the fascinating way in which the courts have developed the right to privacy. Now, as I said, the Fourth Amendment really says you can't enter a person's home, cannot search it. So it's a case of not invading a person's physical privacy. In 1926, the first question came, Olmsted versus United States, where that was the day of prohibition. You know that the US prohibition was a big thing. In fact, people say that was the start of the mafia and so on and so forth. Incidentally, Joseph Kennedy made his money in the prohibition days. But this was the date of prohibition. And this man's phone was being tapped by the FBI because he was a bootlegger. The question arose whether phone tapping amounts to violation of a right to privacy. And the US Supreme Court said, the right to privacy is only regarding your home. They have not invaded your home, they have not searched your home, they have tapped your conversation. So wiretapping is not a violation of a person's right to privacy, because privacy means physical space, physical privacy alone. That was 1926. But those of you who are lawyers, please read the dissenting opinion of Brandeis. With remarkable foresight, he says, we are getting into an age where newer devices are being devised. We do not know where it will lead us. And what a man says in his closet can soon become known to the entire world. So what you say in your bathroom can be known to the world. He says in 1926. So, but Brandeis, in fact, Brandeis wrote the article in 1890 in the Harvard Law Review, where he said the most important right is the right to be left alone. Chandrachud has pointed out that it's not Brandeis first, but some other author has mentioned it earlier, but that's a different story. But the most important right to privacy is the right to be left alone. So Brandeis points out that, look, we are coming into an age of technological development. What you say in the bathroom can be known. So this is a very dangerous thing. I don't think that we should permit wiretapping, but it was a voice in the wilderness. And it's a very funny thing of the law that very often dissenting opinions become landmark judgments later. Right? Whether it is Fazal Ali's dissent in A.K. Gopalan, or it is the dissent of Khanna in JDM Jabalpur, all these become the law later. Now fast forward to 20 years, we come to Katz versus United States. Here what happened? After the war, gambling was a major vice. And Mr. Katz used to transmit the bets, etc. on the phone. So what they did was, they knew they were following Katz. Again, they were following Katz. So they used to know that he goes into a particular phone booth and makes calls. So they put a bug in that phone booth so that they could tap his conversation. So you'd go in, make a call and so on. Now the question was whether putting a bug and recording his conversation is a violation of right to privacy. What do you think? Now the Supreme Court said Olmsted is wrong. When you talk of privacy, it is not a person's physical space, it is his personal space. When he goes into the booth and closes the door, that is his private space. What he speaks, to whom he speaks, what he says is entirely a matter of privacy. You can't record it unless you have an authorized warrant. So Katz was a major decision where they departed from the physical space and went into the case that a man's privacy is not just invading my home and so on, even what you talk, etc., that is entitled for privacy. Then of course the matter goes on further, I won't go into details, but I'll tell you why I mentioned this, because when this Aadhaar case was, the privacy case was being heard, Chief Justice Kher told us that we don't have much time because he was retiring in August, and he asked us to ration or divide the time amongst us. So I was given the task of covering the US law on the subject, and that's how I could make a more detailed study of that. We had studied very cursorily in the law college, but when we studied this, we found out that privacy which was mentioned in 1789, see how it develops. From a mere house, it goes to wiretapping, it goes to tapping of a phone, and then it goes into other areas of human conduct. The right to privacy goes into other areas of human conduct. Let's give two examples and I'll move on. I was shocked to note that till 1965, it was illegal to sell contraceptives in the state of Connecticut. That was challenged in the Supreme Court, Griswold versus Connecticut, another landmark judgment, where they said that my right to privacy includes my right of procreation, my right of having my relationship with my partner, and what I do personally is of no concern to anybody. They struck that law down. And mind you, the contraceptive could not be sold even to married couples. Then, 1972, the law continued that you couldn't sell it to unmarried couples. That also was struck down. So in the US, mind you, in 1972. So this was the law. It's difficult to believe, but this is how. But what I'm saying is, look at how the law of privacy is extended not only to these electronic items, but to areas of personal